Edwina, let me start with you. Could this become part of his defense legally?
I think so, Dan, absolutely. If we look at what the criminal complaint has charged here, the state has charged in counts 2 through 5, the first-degree murder charges related to each of the victims in this case. The prosecution has used the language willfully, deliberately, premeditation, and with malice aforethought. And so what Idaho law tells us, what the court tells us, is that state of mind evidence is always relevant when it goes to one of the necessary elements of the crime. So the defense certainly has to jump through some hoops here. And it's certainly, if they raise the issue of a mental condition for the purposes of a defense, it absolutely opens up Kohberger to examination by the state's experts. But under the charging language, the prosecution elected to utilize in counts 2 through 5, it absolutely opens them up.
Look, Bryan, look, in a lot of cases, right, the defendant has some mental issues, right?
Yeah.
And very often the defense attorney will say, you know, I think that my client has serious condition, concern, but it doesn't rise to the level of, for example, insanity. And is it somehow going to work to his advantage that Idaho doesn't actually have an insanity defense, and so he can sort of sneak in using this other kind of language to present as part of his defense?
I'm going to say it as yes and no, because you can sneak it in and bring it in by saying, I'm not really talking about insanity. I'm talking about his mental state. Does he have the ability to knowingly and willfully commit this crime? It's like analogizing if I sneezed as a reflex. I hit you as I sneeze. Did I intentionally hit you? No, it's a reflex. And that's what they're going to try to use his mental diagnosis. But they can't use it as they would in an insanity defense because that's not there. It's the difference between saying, do you willfully intentionally do this, or can you avoid criminal responsibility?
But in so many states, the insanity defense is really right from wrong. Not every state, but a lot of states, it's did the person understand right from wrong? And it would be very hard to say that this kind of condition would prevent you from understanding, for example, right from wrong, right?
Yeah, so it's a little bit more specific than that. I think New York does a fabulous job of an analogy. If you've ever seen a child sing a song that they probably have no business singing, they can sing and recite the lyrics, but they can't appreciate what that song actually means. That's the insanity defense. Just because I can sing the lyrics to this song, if I don't really know what my mom would call grown folk music, that's the kind of the insanity defense. But here, it's not whether you can sing or appreciate the wrongfulness or rightfulness of the actions. It's, do you have that mental capacity to understand what willful is? And it's a lot more hoops to jump through.
But Edwina, if that's the case, that seems to me then that Idaho law actually works enormously to his advantage by not having a specific definition of insanity, which in most states, and I would think in Idaho in particular, that kind of state would have a tough standard, right, to achieve, to say, this will rise to the level of being an insanity defense. Does it help him?
I think if they can meet the statutory threshold, and what is important about this is the defense doesn't get to sneak this in. This isn't a trial tactic. Under Idaho law, the defense has to put both the court and the prosecution on notice 90 days, at least 90 days in advance of the trial, that they intend to raise this defense.
Right. When I said sneak it in, I didn't mean like literally they weren't going to tell anyone. I meant sort of legally sneak it in, meaning as opposed to just going directly and saying, my client is legally insane. Because Idaho doesn't have this insanity law, what I meant by sneak it in was they can use the language of the statute in Idaho to kind of use a back door to effectively make the same argument.
Correct. I would agree with that, absolutely.
Yeah. And you know, it's interesting that there is this condition that is new. How would that play in the fact that it's not a sort of well-known condition? You'd have a major battle of the experts here, right?
Yeah, it's not like PTSD where many of us know that. I don't even need to tell you what the acronym is.
Right.
But you've got to lay the groundwork for what this is, just like you did in your show here. You tell us what
I'd never heard of this condition.
You show us you tell us what it is, you show us the example, you show how it could affect, and you do the little bits and pieces.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.